There's a proposal right now to limit what prosecutors can do in grand jury proceedings, to allow defense attorneys to be present, and to not allow them to kind of, if one grand jury declines to indict, not to reshop this case to another grand jury. I mean, technically, if they wanted to, they could try and refile this case against Paul Wall. There's nothing that prohibits them from doing it because it's still within the statute of limitations. And what people, maybe people would say, well, what about double jeopardy? Well, double jeopardy doesn't attach unless you have a jury trial. Double jeopardy does not attach at the grand jury level.
Absolutely.
And so there's nothing that would prevent a prosecutor from waiting until this grand jury session expires, waiting until the new grand jury gets impaneled, and going back and saying, hey, we want this charged. So I don't think that would happen with the Ogg administration, but what do you think about this new proposal?
I like the new proposal. I think that the idea of preventing prosecutors from shopping grand juries is a great idea, unless there's new evidence that comes to light. Just like as a defense lawyer, we can't walk into a courtroom, we can't courtroom shop. Mm-hmm. You know, with a few exceptions of a reintegration court, a mental health court, and a few things like that, you know, we don't get to pick the court that our case falls in. You walk in and you work with what you've got, and you hope that, you hope it lands in some courts. And I think that, to a certain extent, the same type of rules should apply to prosecutors. You don't get to shop, wait until a grand jury session expires, and just because you feel that it's appropriate, you shop it in front of another grand jury. It just seems patently unfair to me, unless there's new evidence, and that can be a game changer.